So talk a little bit about what it might cost someone to come and who might need your services or the services of a criminal defense attorney.
And at what point should they consider contacting a criminal defense attorney if they've been arrested?
Well, I mean, at what point is the easier of those two questions? Immediately. When you're arrested, the first thing that's going to happen when they take you to the jail after you're booked is a bond is going to need to be set. If you hire a criminal defense attorney, that attorney can get involved immediately with your representation, which could include meeting with and speaking to a judge about setting a bond for you, or possibly authorizing a signature bond to have a family member or parent sign a bond to release you from jail, as opposed to having to pay a bail bondsman.
Mm-hmm. So a signature bond costs nothing if you can convince the judge to allow that.
If you qualify, and again, that's on a case-by-case basis, depending on whether they've been arrested before and how serious the crime is. And then the next step in the process between your arrest and when you first go to court, which is going to be about a month later, the district attorney's office is going to be reviewing the charges to decide what to charge you with, what crime or not. And if you have an attorney involved in the beginning, and you're not appointed an attorney until charges are filed, but if you hire an attorney in the beginning, you can have your attorney meeting with the district attorney to present any evidence that's favorable to you, information about you, maybe witnesses, maybe other facts and information, other than just the police version of your arrest, which is all they would be considering without an attorney.
And I'm sorry, you may have said this, but what if you can't afford an attorney?
Right. If you can't afford an attorney, you're not entitled to have an attorney appointed to you until after the charges are filed. And at the point of arraignment. At the point of arraignment, when you go into court, before they have you enter a plea of guilty or not guilty, they're going to ask you, can you afford an attorney? And the court is going to go into a discussion with them if they say no, to see if they qualify for a public defense. But
most criminal defense attorneys, they will set a fee, and typically the fee is it's a set amount.
That's correct. Most, I say most, including myself, operate with basically what's called a flat fee. It's a fee to represent you on the case from the beginning to the end, whatever the resolution is, whether it be by dismissal, by plea, or even motions or trial. It's a flat fee that's not an hourly fee.
It depends on the severity of the charges and whether or not you've had prior criminal convictions, which means the stakes are higher.
That's correct. When I'm evaluating a case to decide what kind of fee to charge for the flat fee, I'm looking at whether they've ever been arrested before, have they ever been convicted of any crimes, how serious is the crime that they've been accused of, and I'm going to factor in my time from my experience to see what do I think this is going to take for me to help and resolve this.
And that's fairly typical.
That's pretty much the way most criminal defense attorneys do that.
Well,